motion for summary judgment. And I'm glad to be here because instead of arguing over discovery and procedures, we just get to talk about law and evidence today. And Texas law on summary judgment evidence is very clear and well established. As shown in defendant's motion for summary judgment, the Texas Supreme Court's holding in City of Keller versus Wilson addresses what is conclusive and competent summary judgment evidence. And that holding cites Justice Calvert's no evidence and insufficient evidence points of error, which is the most cited law review article in Texas legal history. And this holding, City of Keller, lists certain types of conclusive evidence in summary judgment hearings. And relevant to the case at bar, it includes physical facts that can't be denied and evidence where a party admits it is true. And as I said, the facts in our motion, defendant's motion, derive from basically two different sources: plaintiff's deposition testimony, which are his admissions, and plaintiff's own pictures of the sloped sidewalk curb that allegedly caused plaintiff's injury. And just to direct the court where that evidence is, those are exhibits B and D respectively in our motion. And when applied to plaintiff's claims, which are a negligence claim, a negligence per se claim, and a gross negligent claim, the evidence conclusively establishes that plaintiff cannot prove the essential elements of its claim and that we are entitled, or the defendant is entitled, to summary judgment as a matter of law. And just to tell the court, remind the court what kind of case this is a non-subscriber employer negligence cause of action where the plaintiff, Mr. Rowe, was carrying food, which is what we are. We are in a food store. Hanmi Food is a wholesale food seller, and he was delivering food from Hanmi Food to another market, Bamboo Asian Market, who we've now taken leave and designated as responsible third party. And plaintiff Chansho Rowe was basically, he moved to the South Korea about 2.5 years ago. And within the past 6 months, he's worked as a variety of different jobs, from an Uber driver to a janitor to a dry cleaner. And in September of 2019 is when he got hired by the defendant, Hanmi Food. And it says that he was hired to, and this is the testimony from the defendant, hired to carry objects, move objects, help load items onto vehicles, and then deliver and unload the items to various restaurants. Plaintiff spent approximately the next month doing exactly this. And he described this as his normal daily work, and this was his routine job. Then on October 22nd, so only about a month in, I mean, this is now October 22nd, 2019, the plaintiff was delivering and unloading food to Bamboo Asian Market, which is up in Wichita Falls, Texas. And plaintiff testified that he was doing this normally, that the things he was delivering were not heavy, and he had already made quite a few trips back and forth from his car into which was given to him by the defendant, into the store. And I think on the 4th or 5th trip, it isn't very clear, plaintiff said that he was stepping up onto a sloped curb where his ankle, he stepped on it and he fell over. And that's where he hurt his ankle. And we have the picture of this that the plaintiff produced, which is Exhibit D, and it shows that sloped curb where he put his ankle and he slipped. And we continued to ask Mr. Rowe questions about this, what it was, and he says there was a small crack in it where he put his foot in there after many times, and he'd already successfully gone through many times, and then on the 4th or 5th trip, just put his foot in an ankle and it turned. Afterwards, Mr. Rowe says he called Hanmi Foods, the defendant, and Mr. Rowe said that he had a conversation with someone who works there, who was the Miss Choi. Miss Choi, he told him that because he was so far away in Wichita, Texas, that he would have to take care of it. And Mr. Rowe, for some reason, thought that take care of it means that he had to continue doing his deliveries instead of going to see a doctor. But we asked him about that, and he said that there was really explicitly, she never said that at all. She just said, you know, you need to go take care of it. Take care of it. Anyway, so Mr. Rowe subsequently finished his deliveries, then afterwards stopped by Walmart to use a bathroom, and then returns to Hanmi, his place of business, the defendant, around 7 p.m. He then went straight home and didn't go to the hospital or to see a doctor, and then he waited to the next day to do so. And since then, he has not asked.
Mr. Rowland, unfortunately, I've read everything. I already know I'm going to rule, and
I'll just skip that. I'm sorry, Your Honor.
That's okay. I didn't tell you that. So, your client is the employer. This is a non-subscriber case. Obviously, the standard for the plaintiff is very low in this case to be able to defeat a summary judgment. I've read they're basically arguing that he was told to rush because it was frozen food and there wasn't a cart provided for him to move the food. Your argument is that he knew about the crack and he should have exercised greater care. Am I summarizing this correctly?
Well, the two parts that we really would like to focus on are the commonly known hazard, because we really give the trilogy of Texas Supreme Court cases on commonly known hazards, and they mirror the facts identically. And commonly known hazard means that there's no duty, and that's a threshold element. And if you look at the page 13 of the motion, we have those three Texas Supreme Court cases, the Jack in the Box.
Right, I've read them.
And I thought it mirrored perfectly because it was the Texas Supreme Court case. It was loading purchases onto a vehicle and doing all these types of things is a commonly known hazard. And it seems like we have the only conclusive summary judgment evidence regarding this issue, because we asked the plaintiff many times whether this was a commonly known hazard. And he said, and I think I'm going to quote him, I'd like to quote the plaintiff here, which is, it's not just me, everyone. The dangers associated, everyone knows this. Stepping onto a curb, everyone. It's a risk commonly known to everyone. In plaintiff's testimony, he said it's common sense. In general, that's what people think. It's not just me, everybody. Because we asked the plaintiff several different times about whether he thought this was a commonly known hazard, stepping up onto a curb. And he said each time, yes, it's not just known to me, that's known to everybody. And the other side has no evidence. So we have conclusive summary judgment evidence regarding this issue of duty, and they have no evidence to refute the commonly known hazard because this is a party admission, which is conclusive summary judgment evidence. And they said—
All right, response. I appreciate it, Mr. Rowland. Response.
Thank you, Your Honor. I think your summary was correct. There was only one clarification, that being that they did have a cart available to Mr. Rowe, but they had instructed him or ordered him that he was not to use it at that particular site. And it was specifically because of the need to rush with this frozen food. And it is this lack of the ability of using the cart that though our client admits that to step up on a step is a common known hazard, it's this lack of the ability to use the cart that causes the dangerous work environment that doesn't allow him to recognize that this other danger was present.
Okay, all right. Thank you, guys. I'm going to go ahead and deny the summary judgment. Do you have an order here? Did you submit an order, Mr. Brown?
I did not, Your Honor. I can prepare one immediately and send it to the court if that would be okay.
If you could just share it with Mr. Rowland and then get it to the court. I'm going to sign it on Friday, so just try to get it to us before Friday.
Thank you, Your Honor.
All right, guys. Thank you so much. We appreciate it. You have a good day.
You as well. Thank you, Your Honor.
Okay, our next hearing is Mark Hume versus 5 Star Global. I see a bunch of people here. Is it all in that case?
Yes, Your Honor.
We have quite a few people here. I think we were kind of trying to decide about the receiver issue. Is that kind of what this hearing's about?
Yes, Your Honor. Yes, Your Honor.
All right. So kind of, Ms. Shigaris, why don't you just update me on everything?
Yes, a few housekeeping matters, Your Honor. Today's hearing, we have 30 minutes to present oral argument. If you recall at the last status conference that we had, the parties agreed to submit all of the evidence for the receivership application by way of affidavit to the court, which we have, and then we requested some time just to present oral argument. I believe the court only has 30 minutes for us, so we would request that.
Not even that at this point, but yes.
Given the significant issues, we would request at least the time be split evenly, because we've tried to narrow it as best we can, but we have about 15 minutes of argument that we'd like to present. The other two housekeeping matters, we won't have time today to resolve the objections that were submitted by the parties, but I have tendered a checklist order to Your Honor along with our evidentiary objections. Some of that's important because the plaintiff submitted deposition transcripts that they obtained in a separate case from Judge Tillery's court where we are not a party. And there was a specific ruling by Judge Tillery that the plaintiffs would not be allowed to use those transcripts against FSG because the plaintiffs objected to us appearing at that deposition. So we've tendered those for Your Honor, but I know we don't have time today to go through that. And then the last housekeeping matter that we would have, Your Honor, is we anticipate both sides will be talking about confidential financial information related to the company. That's the target of the application. And we would respectfully request that we not broadcast this hearing on YouTube.
Okay. We have a lot of folks from other hearings. Do we want to go ahead and hear those first and then do you guys afterwards, or kind of how do you want to deal with this?
We would be okay with that. I mean, obviously we need to protect the company financial information. So
yeah, I'm not fussing with you about it. I just have other people on other hearings, I think. Do we have anyone here who's not on this case, the Hume versus 5-Star case, Ms. Lopez? Or is everyone here on that case? Maybe everyone is.
I believe, Your Honor, that everyone is here on this case.
Oh, okay.
At least the people that are visible. I don't know if there's anyone that has their video muted. I see some phone numbers that have called in. Those I don't recognize.
Who's here on the phone?
Your Honor, I think those are from my office. This is Julie Pettit speaking. I believe those are from my office and are with our case.
Okay.